We should expect that in a democratic society, one not ruled by a king or autocrat, that is a society based on the equal freedom and status of its members, reasonable people will disagree about many things. Some of the deepest questions about morality, religion, and value are hard to think through. Even people who are well motivated and conscientious will answer questions pertaining to some of these matters in different ways, perhaps because of their different life experiences or because the facts are hard to pin down and admit of various interpretations, or because they'll make different trade-offs among competing values. Disagreement is a feature of a democratic society, not a bug. But not all disagreement is productive. Sometimes people fail to consider inconvenient facts and close their minds to evidence and reasoning that doesn't support their view. Sometimes, all too frequently in online platforms, a culture of incivility prevails with respect to those with whom we disagree. Note that by incivility, we're not talking about politeness. We're talking about the failure to treat other people with respect simply because they hold different views on matters that we care about. The closing of the mind is especially a concern for a university. The fundamental mission of the university, the pursuit of knowledge, absolutely depends on the free exchange of ideas and on openness to questioning received opinions. History shows us how often we get things wrong, even when we're trying to figure out the truth. And it's because we feel this mission, the pursuit of knowledge, is under stress from forces both outside and inside the university that Deborah and I we decided last year to launch this class. Furthermore, we believe what closed minds are not good for is democracy. They're not good for democracy in universities, and we have a role to play in producing responsible citizens. But feel free to disagree. Each week, we've had scholars who disagree, sometimes quite strongly, about major policy issues, but each is committed to following the evidence and to try to present reasons that others can understand and acknowledge. Today's class focuses on the Supreme Court's 2024 decision in Trump v. United States concerning the immunity of a former president from criminal prosecution for certain acts while serving as president. Our speakers will each present their views for about 10 minutes and then participate in a conversation with each other. I'll serve as moderator and may ask some questions. And after the first hour or so, the floor will then be open to questions and comments from all of you. We'll also survey the audience at the beginning and the end of each class to see whether the arguments moved your minds. That said, even when minds are not moved, we hope the class gives you an appreciation for the reasoning behind the views that you reject. First, though, please take a minute to use the QR code to confirm your attendance if you're signed up for the class. So we're extraordinarily fortunate to have today's two renowned constitutional scholars, among several others, from Stanford Law School. Bernadette Myler is Carl and Sheila Spaeth Professor of Law and a scholar of British and American constitutional law and law of humanities. Her research and teaching examines the long history of constitutionalism, reaching back into the English common law ancestry of the U.S. Constitution. Her books stem from these respective areas of scholarship. For example, her 2019 book, Theaters of Pardoning, demonstrates that the representation of pardoning tracks changing conceptions of sovereignty within the plays and politics of 17th century England. Her current project on common law originalism, we learned something about originalism last week, and I expect that will come back today as well. This current project shifts to the American context, looking at multiple 18th century common law meanings, both colonial and English, of various constitutional terms and phrases. After receiving her BA in literature with a focus on classics at Harvard, Professor Myler obtained her JD from Stanford Law School and completed a PhD in English at UC Irvine. She clerked for Judge Robert Katzmann of the U.S. Court of Appeals for the Second Circuit, and before joining our faculty, she taught at Cornell Law School. Last year, Professor Myler changed chaired the Faculty Senate's Ad Hoc Committee on University Speech, which developed two major documents that were adopted by the Senate, a statement on freedom of expression and a statement on institutional policies, on institutional policy statements. She's currently serving as special advisor to the provost to help clarify and further develop and implement policies concerning free expression and academic freedom. Michael McConnell is the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School, and also a Senior Fellow at the Hoover Institution. He holds a BA from Michigan State University and a JD from the University of Chicago Law School. After graduation, he served as a law clerk to Supreme Court Justice William J. Brennan and D.C. Circuit Chief Judge J. Scully Wright. From 2002 to 2009, he himself was a circuit court judge on the United States Court of Appeals for the 10th Circuit. He was nominated by President George W. Bush, a Republican, unanimously confirmed by a Democratic Senate, something that has not frequently happened in recent times. Before joining our faculty, Professor McConnell taught at the University of Chicago and the University of Utah Law Schools. He teaches and writes about constitutional law, constitutional history, and interpretive theory. His books include The President Who Would Not Be King, Executive Power Under the Constitution, and the co-authored Agreeing to Disagree, How the Establishment Clause Protects Religious Diversity and Freedom of Conscience. Paralleling Professor Myler's public service to the university, Professor McConnell has argued 16 cases in the United States Supreme Court. So today's discussion centers around the Supreme Court's decision in Trump v. United States, and here's the background largely quoted from the beginning of the court's opinion. From January 2017 until January 2021, Donald J. Trump served as President of the United States. On August 1, 2023, a federal grand jury indicted him on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing the election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of election results. The district court denied a motion by a former president to dismiss, holding that, quote, former presidents do not possess absolute federal and criminal immunity for any acts committed while in office. The D.C. Court of Appeals affirmed. The Supreme Court granted certiorari, this is a technical term, means they have the discretion to review or not review a lower court decision. In this case, they granted review to consider the following question: whether and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? Before turning to our 2 guests, let's put up a poll. We'll proceed each week's conversation, as you know, with a poll on a relevant question and then ask the same question after their conversation and the Q&A. What conclusions you draw from different results, if in fact they differ, is completely up to you, but if nothing else, it may provide some food for thought. So here is the poll. And should former president have absolute immunity? So the poll can only move in one direction. And with that, let me ask Bernie Myler to come up first, followed by
Now I'm worried that speaking at all will cause my side to lose votes, so I apologize in advance. So as you just heard from Professor Brest, the Supreme Court in Trump against the United States held that the president did enjoy immunity a former president does enjoy immunity presumptively for conduct involving official acts, so that there's a presumption that should apply whenever a president is facing criminal prosecution, that they will be immune, and that presumption is rebuttable by the government's demonstration to the contrary, with somewhat unclear boundaries of what that demonstration would include. So the question is kind of where this official immunity comes from. And I want to go through some possibilities with you and suggest that there really is no good source for finding the president immune with respect to his official acts. Now, the default we might have under a kind of originalist court or a textualist court would be to look at the text of the Constitution. But when we look at the text of the Constitution, we don't see any form of presidential immunity explicitly mentioned. And the question of whether something is textually provided or not has become even more salient in recent years for the Supreme Court. And for example, in the Dobbs case decided a couple of years ago, Justice Alito explicitly referenced the fact that there was no right of privacy written into the Constitution in deciding that the Roe v. Wade case should be overturned. So there has been a lot of reliance on text, and there's no text in favor of presidential immunity in the Constitution, nor is there text denying it. So we might say, well, maybe the court should just stay out of this, given that there is no text. And I think one of the themes of my remarks will be what would be the appropriate kind of judicial deference in this case. Now, a second question might be, well, we don't have text, so can we find anything structurally in the Constitution that suggests one way or the other whether the president should enjoy immunity for official acts? And the court there goes to an important precedent, the Youngstown case, often called the steel seizure case, involving President Truman's effort to seize the steel mills and keep them running in the face of a possible strike. And this was during the Korean War. He thought that there was an exigency that required seizure of the steel mills in order to maintain production for war purposes. Now, what happened in that case, there were a lot of different opinions, but one of the opinions that has gotten the most traction in recent decades is the Justice Jackson opinion, which divides presidential action into three categories. And the first category is the category kind of at the highest ebb of the president's power. So that's when the president acts with the explicit consent of Congress. And then there's what is called the zone of twilight, which is referred to in the opinion. And that's where the Constitution isn't clear or the congressional authority isn't clear. And there might be some need to reference history or other kinds of pragmatic factors in order to decide whether or not the president might have power. And then there's another category, which Jackson says is the lowest ebb of power, and that's where Congress has explicitly denied a power to the president, and the president has no independent constitutional authority. So an example of where a president would still have constitutional authority, even in the lowest ebb, would be, for example, the pardon power, where the Constitution explicitly grants the president the power to pardon, and that's discussed in this opinion in Trump against the United States. Now, the Trump against the United States opinion says, well, this is happening in the zone of twilight. We really don't know, so we just have to look to these other factors to determine whether or not the president had authority. Now, I would argue that actually that's not true, that there are a web of congressional statutes involved here. The whole point of the prosecution was to implement those congressional statutes in relation to the president. And there wasn't a determination yet that they were unconstitutional as applied to the president. So in fact, you could argue that this is actually a situation at the lowest ebb of the president's power. So I don't think that Youngstown or a kind of structural analysis necessarily supports finding presumptive immunity for official acts either. In addition, if we look at the kind of pragmatic basis for the opinion and the pragmatic justification, one of the arguments that the court makes is that the founders really wanted there to be an energetic executive, a vigorous executive, who would be able to act in emergencies not to be hampered or hamstrung by the other branches or by excessive deliberation. And that certainly was one of the factors that was discussed at the time of the founding. At the same time, there's evidence that presidential power has only increased over time, that in fact the energy of the executive isn't really an issue, that in fact it's Congress that has become eclipsed in a lot of domains by excessive exercises of presidential power, for example, in the area of the war powers or in many other domains. Now, thinking about this, so we might say, well, okay, so maybe the executive is energetic enough. There are other kind of pragmatic factors too that would lead me to say that that presumptive immunity for official acts would not have been something the framers would have wanted, and that has to do with the fact that they thought that impeachment might be a broader remedy for presidential behavior than it has been in the past. So to return to the pardoning example, one of the remedies for abuses of the pardon power, if it was excessively used, that the framers talked about was impeachment. Of course, it hasn't been very plausible to resort to impeachment, or at least it hasn't been successful resorting to impeachment to cabin presidential power. So I think that the balance that the framers might have thought that they were striking between energy and enforcing social norms or enforcing legal norms hasn't been implemented in the way that they might have imagined at the time of the founding, given the fact that impeachment has become so unusual. Now, there's also another problem, I think, with the opinion, which is that it talks about presumptive immunity for official acts, but it really doesn't sufficiently define what official acts are. Now, let's take the example that is discussed a little bit of discussions with the vice president about various kinds of things like election certification, et cetera. Now, okay, so there could be a lot of ways in which discussions with the vice president and between the president and vice president could be official acts. There could also be other ways in which they're not. Maybe they're discussing dinner plans with someone who has no political relation but is just an old friend of theirs from college. Maybe they're discussing a bribe. Is that an official act? What if the president is poisoning the vice president? Is that an official act? So where in that set of interactions does the act depart from being an official act, or are those all official acts because they involve interaction with the vice president? Now, this kind of draws on a line of cases that often treat what's official or unofficial in a way as a legal fiction. So there's another case called Ex parte Young that allows for state officers, state executive officers, to be sued for injunctive relief, so for, to prevent them from doing something unconstitutional. And the fiction there is that they're not part of the government at that point, or that they don't enjoy sovereign immunity, because they're acting in their private capacity rather than their official capacity. And the idea there is that once they start acting unconstitutionally, they're no longer acting in an official capacity. So could we say that the president is no longer acting in an official capacity when the president acts unconstitutionally? Is that part of how we could implement this decision? So I think ultimately it's unworkable to think about how to implement the decision in terms of deciding what kinds of acts are official acts or not official acts, and then having a district court determine whether or not the president should be immune on that basis. Now, I think, there might be a concern if there were no alternatives to finding that the president was presumptively immune, or a former president was presumptively immune from criminal prosecution for acts in office. Certainly, there are possible scenarios where that involve political persecution or various kinds of retaliation by one presidential regime against another, where it might seem that there should be some form of immunity from being called into court for perfectly reasonable decisions and perfectly constitutional and legal decisions of a prior president. Now, the alternative, though, I think is well put by Justice Barrett, who concurred in the judgment. And I think that that alternative is to just strike down a statute as applied to the president as unconstitutional if it somehow cabined the president's constitutional authority or didn't allow them to fully implement their judgment in doing things that were otherwise constitutional. So I think there are plenty of alternatives that exist, including that one, for making sure that political prosecutions didn't plague former presidents, and that would require much less immunity than the court is arguing for. And my final point is that basically, and this is related back to the topic of the class, which is really about discussion on controversial issues. And what I think that allowing for presidential immunity does, or the immunity of a former president, is to close off discussion. So part of what happens in the criminal process is uncovering the events that actually occurred, or uncovering the circumstances that led to a particular claim of criminality. And if there are reasons to believe that those claims are unjustified, or that there's a constitutional defense, then that should come out in court rather than being hidden away because of a claim of presumptive immunity. So I think that one of the many harms of a presumption of immunity is that it closes off the conversation rather than beginning it. Thank you.
So 94-6, I don't have much to do here. Actually, it's nice always to be taking a very minority position, because nobody can blame me if I don't persuade very many people. It isn't actually my ambition to persuade you that the Supreme Court decision was right. What I would like to persuade you, though, is that there were very reasonable grounds for it. No one should have been surprised by the decision, and actually nobody should be very distressed by the decision either. Maybe it was wrong, but not catastrophically wrong. And I'd like to begin just by suggesting how that it's important when thinking about separation of powers cases like this, not to get too caught up in the particular personalities who are involved. This case was United States versus Trump, right? And many people think about it, about the question of presidential immunity, with Donald Trump's smiling face before us. But this case really wasn't about Mr. Trump. In fact, I would sort of snarkily suggest that the biggest beneficiary of this decision was actually Joe Biden. He's the one most likely to be prosecuted by a vindictive subsequent presidency. He should be very glad that Donald Trump won in this immunity case. And you might say, well, not very many presidents do criminal acts, but actually many official acts of presidents can easily be characterized as criminal, and then could have cases brought against them. Just to give one recent example, President Obama ordered the killing of Anwar al-Awlaki by drones. Awlaki was an American citizen. Many people passionately believed that this ordered killing was in violation of both international law and domestic law. Had he had the bad fortune to have a successor in office who was looking for some basis for prosecuting him, that would not have been a frivolous prosecution. So in all separation of powers cases, it's, I think, very valuable to think about a president that you really like or a president you really dislike in the opposite position, and not to make the mistake of letting your feelings about the particular person involved affect you. And I would argue that the decision here would have come out the same way if it had been a Democratic president. I think that is true. Now, where do I get this? Many of Professor Mylar's observations I totally agree with, and it's by no means clear that it's an original matter back in 1790 or so that a president would have been recognized as having, a former president would have been recognized as having immunity. I'm not sure about that, but the Supreme Court does not decide cases in a vacuum. We've had there's been a lot of water under the bridge, and the court must take all of that into consideration. To begin with, it is not at all unusual for the Supreme Court to recognize absolute immunities for officers of the government that are not based in the text of the Constitution, and indeed based in nothing more than exactly what we have here. So, for example, the justices writing the dissent who were complaining that immunity was a sign of that, well, that's like a king. That would suggest we're no longer, in a democracy. Well, those justices themselves have been given absolute immunity for their official acts. That is nowhere in the Constitution, and it first came up in a Supreme Court decision in 1976. Judges have absolute immunity for their official acts. That's not the worst of it. Prosecutors, who are particularly dangerous, they wield powers that are particularly dangerous for the liberties of the people. They are absolutely immune for their prosecutorial conduct and their decisions. And indeed, even people who are working with prosecutors, including police officers. I represented a client who was trying to sue a police officer who was responsible for keeping him behind bars for 27 years, and we now know to a certainty that he was innocent. And this police officer lied to the prosecutor about an important fact in the case. Absolutely immune because he was working with a prosecutor. That's nowhere in the text of the Constitution. The Supreme Court has created that. In both cases, the logic was exactly the same as in Trump against the United States, namely that the threat of future liability or prosecution for official acts would lead the officer to be overly cautious. They'd be constantly, instead of thinking about what they should do, and sometimes when people think about what they should do, they do terrible things. Right? But instead of thinking about what they should do, they'll be looking over their shoulder about what the possible consequences for their own hides will be. And the Supreme Court says that's not what we want. Congressional aides also have absolute immunity for the legislative conduct that they engage in. I think it would be a little bit odd if the only major officer of the federal government who did not have immunity for their official acts is the President of the United States, because it would seem to me that the arguments for congressional aides and prosecutors and all these other people, these count so much more for the president. We do not want the president to be constantly worried about future legal consequences when he's making decisions about whether to order a drone strike on an apparent terrorist who is threatening our troops. We don't want that. We don't want Harry Truman to be worried about being brought into court as a mass murderer when he orders the bombing of Nagasaki. So that's one point. Lots of other, court has been finding immunities for lots of officers, so without any ground in the constitutional text. And there's something even more specific, which the court had in front of it, and that's a case called Nixon against Fitzgerald. This was a 1982 decision of the Supreme Court that held that the president, a former president, it was former President Nixon, was absolutely immune from civil liability for all official acts. Actually, this is more sweeping than anything that was held in the United States, in Trump against the United States, because it's absolute for all official acts. Indeed, what the court said is all acts that are within the outer perimeter of the president's authority, absolute immunity from civil liability. They can't be sued. Now, that might be wrong. I'm not at all persuaded that Nixon versus Fitzgerald was a correct decision, but Jack Smith, going into the Supreme Court, accepted Nixon versus Fitzgerald. He agreed that Nixon versus Fitzgerald was correctly decided. So it was not argued to the U.S. Supreme Court that that civil immunity was something which is something that is wrong. And so here's what Jack Smith argued instead. He said that criminal liability is less dangerous to the president, less likely to force the president to be too circumspect and look over his shoulder too much. Less likely. Now, I ask you, if you were in this situation, which would you be more worried about, having a lawsuit filed against you or the possibility of being thrown in prison for what you did? It seems to me that's highly illogical. And Smith's argument beyond that is even more illogical. What he said is we can count, it's not dangerous to the president because we can count on the professionalism of the prosecutors in the prosecutors' offices not to abuse this possible power. Now, okay, I'm all in favor of prosecutors. Many of them are good friends of mine. I do not think the last 4 years have shown us that prosecutors refrain from bringing politicized charges against other people. And even if the last 4 years didn't, I swear the next 4 years don't. Who could possibly believe that the prosecutors in the Trump administration are too professional to bring vindictive prosecutions against Joe Biden and his people? It seems to me an almost fanciful notion that the professionalism of prosecutors is sufficient protection. And that was the argument being made for why Nixon versus Fitzgerald, which is about civil liability, should not be extended to criminal liability as well. Just one last point. Professor Mylar made a passing reference to an argument made by Justice Amy Coney Barrett. Barrett said, in a fairly short a concurrence that I think was extremely well thought through, she said, the result in the case is right, but the way it is framed is not the way she would do it. She suggested that rather than talking about immunity, the real question is whether it is constitutional for Congress to pass laws governing how the president would exercise the essential official functions of his office. Now, remember what the holding was. It was that the president is absolutely immune for exercising the inherent and exclusive powers of the president. Only presumptively is the president immune from prosecution with respect to other official functions. Now, I don't know what presumptively means, but my guess is that this is going to be a kind of case-by-case reasonable analysis as to whether whatever the president did was, really terrible, or whether it was within the reasonable basis of his official duties. The real sticking point of the holding has to do with the inherent and exclusive powers of the president, and that's where the absolute immunity comes in. There are not very many official powers that are exclusive, that are inherent and exclusive. There's the pardon power, there's the veto power, there's the power of the president to supervise and control the subordinate officials within the executive branch. I could tick off 2 or 3 others. There are not very many of those. And Congress is not entitled, the implication of Justice Barrett's opinion, which I think I heard my colleague endorse, the implication of that is that it's just not, it isn't that the president is immune, it's that Congress cannot make it a crime for the president to exercise, for example, the pardon power in some corrupt way. It's easy enough to see corrupt pardons. I think we have seen some just in the last few weeks, but that doesn't mean that Congress has the constitutional authority to reduce the scope of the unlimited pardon power by making a corrupt use of that power illegal. So maybe we shouldn't be talking about immunity at all. What we should be talking about is whether Congress has the authority to criminalize acts that are within the official and exclusive power of the president. One last point, really returning to the initial thought that this case is not about Trump. It's probably more about Joe Biden than it is about Trump. But the final point is, Jack Smith litigated this all the way up. It looked like a very big case. The Supreme Court held it against the Smith position. He held that the president does have these immunities, and then afterwards, Smith complied with that by altering the scope of the indictment against Donald Trump. And what did it amount to? It eliminated one of the charges against him. Almost everything that Donald Trump has been accused of has been private conduct. So they eliminated, Smith eliminated from the indictment charges having to do with the president's instructing the Department of Justice to investigate the alleged supposed fraud in the election. That's all that happened. So should you be distressed? I suggest you should not be particularly distressed about that. It was not a big deal for Trump. It may be a pretty darn good protection for Joe Biden. It seems consistent with the way the Supreme Court has dealt with non-textually based immunities for other officers. It seems consistent with the precedent of Nixon versus Fitzgerald, which no one asked to be overruled. And I think that's pretty good for a day. Thank you.
You can just hold up the mic.
So, I agree with many of your points, Michael. Also, I think that I do endorse the Barrett position to some extent, and think that an as-applied challenge to the constitutionality of a statute that purports to cabin the president's official powers would be appropriate. I also think you're right that Nixon v. Fitzgerald and other cases do suggest that there is immunity in other arenas for the president and then also for other officials. I would take issue with some of the breadth of the immunity for other kinds of officials. And as you say, it's of relatively recent origin, many of the decisions, and they have a kind of ad hoc feeling to my reading. But I guess one thing I would also say that I do agree with you about is on the fact that we shouldn't be overly focused on the person as opposed to the structure in the separation of powers context. And I would tend to agree that Biden may be a bigger recipient of the benefit of this decision than Trump. Someone was just asking me recently why Biden hadn't pardoned himself in addition to the constitutional problems potentially from that. And, I think one of the answers might be that he, sought protection under this decision from any potentially politically motivated prosecutions coming out of the Trump Justice Department. So, I agree with a lot of the premises that you articulated, but I think I still, I would disagree more generally with a lot of the precedents involving immunity for other kinds of officers. And then I would also point to the fact that there has been precedent suggesting that a president could testify in other kinds of proceedings. And so, that goes to the point of being able to collect sufficient information about what happened even in official types of proceedings.
I think we may surprisingly agree on more than we disagree. Therefore, I think at the very end you're referring to something we hadn't talked about yet, and just to make clear what that is, there is a paragraph in the majority opinion which says that the official acts of the president not cannot be criminally charged based upon those acts, but that can't be used as evidence in something with regard to private conduct. Let me say I disagree with that. Not only do I disagree with that, I don't see what could be the basis for that. And not only that, but I don't see how the Supreme Court could have even had any authority to opine on that question, because Trump against United States did not involve the use of official acts as evidence in a case involving private conduct. The Supreme Court is, they don't always obey this any more than we always obey speed limits, but the Supreme Court is supposed to issue rulings of law only on issues that are before it in the case. That issue was not before it, and I think they probably got it wrong. And that, by the way, was the argument in the New York case involves plainly private conduct. I actually don't believe that it was criminal conduct, or at least not felony conduct, but clearly private. And yet, Trump's lawyers argued that the conviction needed to be thrown out because there was testimony about official acts in the course of talking about the private acts that were at issue there. I think that was baseless.
Let me ask a question about constitutional interpretation, and I should tell the two of you that last week the discussion we had about different approaches to changing the structure of the court led to a broader discussion of constitutional interpretation and originalism in particular. The majority of the court, I think, consists of self-declared originalists. How does the majority opinion square with an originalist approach to constitutional interpretation?
I don't think there's a word of the opinion which is based on originalist interpretation. It's just not that. It's based upon some combination of precedent, in some cases long-standing precedent, and functionalist justifications. It's not an originalist opinion. Justices sometimes say they're originalists, and sometimes they are, but they're not always.
Yeah, I would say that there's one way in which a broad understanding of originalism might see some of this as originalist. And so, just to kind of get into a little bit more of the theories of originalism. One of the dominant methods today is original meaning originalism rather than original intent originalism. Paul is too modest to tell you that he kind of invented the term originalism in an article he wrote a long time ago. But when he wrote the article, it was really about original intent. So that would mean that what the founders thought that they were doing, or the framers of the Constitution thought they were doing with a particular clause. But then people pointed out that they had a lot of different views, and so how could there be one original meaning in that case? And then Justice Scalia and others went to the idea that it's actually original public meaning that we should be looking at, because that's the meaning that the ratifiers would have understood at the time of the founding. All the people who were ratifying the Constitution would have interpreted the clauses according to kind of what the meaning that they understood would have been of the terms at the time. And so that's been the dominant view of originalism for a long time. But there's a way in which some of this opinion goes back to maybe a kind of original intent version of originalism, where there is a discussion of the purposes behind the executive power and the overall understanding of the framers in how they constructed the executive branch and the idea of the kind of energy and vigor of the executive. And so that's, I think, maybe inclining a bit more towards this, kind of original values or original intent vision of originalism, if there is any part of originalism to be found in the opinion.
May I just draw a distinction here about what it means to be consistent with originalism? One possibility is that all of the decisions have to be based upon evidence, actual historical evidence regarding the meaning of the terms of the Constitution. That would be a very strict version of originalism. But there is a softer version that I think is maybe more descriptive of what the court does more often, and that is that it's sort of originalist enough if they don't do anything that is contrary to what we know was the original meaning of the Constitution. And Lord knows they've done that often enough over the 235 years. But this opinion does not appear to be contrary to anything we know about the original understanding of the Constitution. And there are little snippets of evidence that might support it. These were not things that the majority opinion invokes as basis for decision, but may give some comfort to those people who are original, or soft originalists, who think we don't want to do anything that's contrary to what the framers understood. So just one bit. James Wilson, who was one of the 2 or 3 most important framers of the Constitution in Philadelphia in 1787, at the Pennsylvania Ratifying Convention, said the following, and I quote, "Far from being above the laws, the president is amenable to them in his private character as a citizen and in his public character by impeachment," which I think means that private conduct of the president is a matter for the laws, for the ordinary criminal and civil laws of the United States, and acts in his public character, that would be official acts, the proper forum for raising those is impeachment. Now, I hasten to say, Professor Myler was totally correct when she says that the framers thought that impeachment was going to be a much more potent instrument than it has turned out to be. In our highly partisan days, where senators can almost never vote, very few of them vote to convict on an impeachment of a president of their own party, impeachment now seems kind of like it's not a very potent tool. but I think the framers expected it to be. And they thought that if a president in his official capacity did something that was wrong, that impeachment was the proper way to go about it.
Let me ask you a non-doctrinal question. The majority is composed largely of what are thought to be conservative justices on the court, and the dissents are composed of what are thought to be liberal justices. Why would the court divide in that way on this question? Why would one not expect to find liberal and conservative justices on both sides of the issue?
Take that.
Okay, I mean, one non-partisan way of reading it would be to say that actually it's usually the conservative justices who've promoted a more expansive vision of executive power. So there's an idea of the so-called unitary executive, which promotes the idea that the main way of attaining political accountability in the executive branch is by having the president really supervise all of the people in the executive branch. They can fire them at will, and we see what's happening with that currently under Trump. So that idea of the unitary executive, an idea of kind of broad executive power, has often been something that the more conservative justices have promoted generally. My other thought about this is that, to me, I feel that Justice Barrett's opinion is a more reasonable way of addressing this situation, because it preserves a kind of judicial modesty while also, making sure that the president isn't held into court for things that would be something protected as a kind of presidential responsibility. In this kind of case where it is a very politicized situation leading to the Supreme Court's intervention, I think it is the duty of the justices to try as much as possible to take a less politicized tack in deciding the case. So I felt that the opinion fell short in that respect in this case.
Just to point out that this was not the only, highly politicized and partisan issue involving Mr. Trump in the courts in the last few years, and it hasn't always been quite the way. This one divided, as you say, Paul. All of the Republican-nominated justices voted on one side, and all of the Democratic-appointed justices were on the other. But just a few months earlier, they had an equally explosive, very political case having to do with whether Mr. Trump's alleged participation in an insurrection disqualified him from running for president under Section 3 of the 14th Amendment. And that was unanimously rejected by the Supreme Court. So they did not divide on partisan grounds. It was unanimous. And then I also think that it's worth remembering all of the election fraud litigation around the country. The Trump campaign brought, I'm forgetting now the numbers, was it 63 different lawsuits around the country? I don't know that that's the correct number, but that's on the order, alleging that his defeats in various places were the product of election fraud. Not a single judge found in favor of the Trump campaign, and many of those decisions were written not just by Republican-appointed judges, but by Trump-appointed judges. So just because Trump appointed the judge did not mean that the judges would decide in Trump's favor in this election litigation. It's also maybe worth noting that Trump's people were calling on Republican state legislatures to try to do various things, decertify the elections or appoint different electors or, do one thing or another in order to deprive Joe Biden of his electoral victory. Not a single Republican legislature did that. They all refused. There was also a lot of pressure brought to bear on Vice President Mike Pence to do something that might help Trump prevail, and he refused. So I think in all of our like depression about hyperpartisanship and does our government really work, let's give them credit sometimes that our system held pretty well. There are a lot of guardrails, and they held, and they often held cross-party lines and with judges and elected officials refusing to cooperate with their own party leaders' efforts, and that makes me feel good about the system.
Any comments on that, Bernie? Before we open it up to questions, any issues that the two of you have not discussed related to the case or not that you might like to talk about?
The timing of the case is really strange. If you assume that the Justice Department really believed that former President Trump should be prosecuted for what he did, it was all the acts took place in November, December, and January of 2020 and 2021. It's true we didn't know every detail of the evidence, but we knew a lot. And the House investigating committee produced still more. And they had a criminal referral to the Department of Justice recommending that Mr. Trump be prosecuted. And nothing happened. The Department of Justice did nothing until well into the last half, and then they began doing something, and they did it with excruciating slowness. And even on this issue of immunity, we all knew from the beginning that the immunity question only affected a very small part of the Smith indictments against Mr. Trump. We all, at least all lawyers looking at this, knew that that was the case, and he could have done what he did at the end, only done it 2 years earlier, and changed the indictment so as to make this whole question unnecessary, and then bring charges like 2 years before, and he didn't do that. Instead, it was timed in such a way that it looked as though it was going to land the leading candidate for president of the other political party in court and have to sit there every day during the campaign. Now that in the end didn't happen, but it looked like it was going to happen. And I have to say, I find that rather abusive, to be able to use the powers of prosecution and to time it so unnecessarily so as to take the presidential candidate off the campaign trail for what probably would have been a 3-month criminal trial. I don't like that.
So it's open to you. Let me remind you that this is your second week of legal education, and that I hope you'll come to the microphones, and people who ask really smart questions will get, additional points for your application to Stanford Law School. I think I scared everybody off.
You won't be forced to attend Stanford Law School, don't worry.
Hi. First off, thank you very much, presenters. This was a wonderful discussion. I have a question for you specifically, Professor McConnell. So from my understanding, the main argument for immunity is kind of the idea that if we don't have this immunity, our leaders are going to be afraid to make these decisive actions that they need to make, but there might be backlash to it. But these decisive actions sometimes end up going wrong, and immunity ends up protecting them for this. So is there any way that we could get like a best of both worlds where we have immunity and candidates, leaders are encouraged to make these decisive actions, but when they do something wrong, they still face the consequences of it so that it doesn't get kind of used and abused? Or are these two ideas just uncorrelated?
I like the question, and I wish I had a brilliant answer for you, but I don't. I think, again, a very typical case would be President Obama's ordering the killing of Al-Awlaki. Yeah. He had to do that under, well, Al-Awlaki was on the move. There was a moment to do it. Yeah. He had to move very quickly or not at all. And, maybe he made the wrong decision. I mean, Al-Awlaki is an American citizen. There was no due process. This is international law has is there. It could have been wrong, but I have to say I really want that President Obama be thinking about the rights and wrongs of it in that moment and not asking his lawyer whether this is going to get him into trouble. Yeah. So I can't think of a middle ground. Maybe there is one, but I can't think of it.
But
wish I could.
Almost overall, just the value of having our leaders be able to make this decisive action outweighs the occasional wrong they would make.
I guess that's where I come out.
Yeah. All right.
It's nice to have your cake and eat it too, but sometimes we can't.
Yes, sir. Thank you.
Thank you to Michael and Bernie and Paul. Not being a legal scholar, some of that's a little bit harder to follow, but from a comparativist perspective, I'm wondering if both of you could speak to what do we see happening around the world? So where do we have examples of countries where there isn't presidential immunity, and how does that play out? Because I'm thinking from the perspective, as I'm sure we all are, especially in democratic societies, but what does it start to look like when our leaders can be prosecuted, as compared to not, and what are we learning from other cases?
I mean, I think in general, prosecuting the leaders of the other party, former leaders, is more associated with banana republics than the United States.
I mean, I guess, so there are two things I would mention. So I think, like, going back historically to the British example, there, I think, is an interesting counterpoint here where impeachment was not only like a more vigorous process, but also actually could even, extend to death, right? So we have the impeachment of Charles I, which, resulted in his execution. But there was a sense that actually there could be material consequences for leaders kind of stepping outside of their allocated authority, and that would be delivered by legislatures. And so I think that that's an interesting kind of contrast. In terms of the use of, kind of a criminal justice process, I would tend to, agree in part with Michael that using criminal justice often to, penalize predecessors, I think can be excessive and has been excessive in a lot of other countries' contexts. And so that, there is a risk of overuse of the criminal process to prosecute prior regimes, or and that there will be then cycles of kind of vengeance that are perpetuated through that. So I think that is an unfortunate example abroad. Otherwise, I'm not as sure about other regimes in terms of the immunity decisions. I don't know exactly in terms of, like, say, the European protocols with respect to immunity, how those are arranged, but that's a great question.
Thanks, and so just to clarify, in an earlier session, we had Jeremy Waldron and on free speech, and so I think that's where I was getting at around the comparative perspective that was offered there about our European counterparts in New Zealand, et cetera, that we were kind of an outlier. So it sounds like that maybe we don't, this isn't your area of expertise, but saying back to you, Michael, is there anything beyond the area of the world that you discussed what we know about our European counterparts?
I'm not an expert on this, but let me just give a personal note. The moment I knew, I'm often a Republican, the moment I knew that I would not vote for Donald Trump ever was when he started leading his rallies and the chant, "Lock her up." Do you remember that? Lock her up. And to me, that is using the prosecutorial system to go after your political enemies is a deep-dyed violation of our rule of law norms. Now, maybe total immunity looks like it's going too far, but what it's warding against is lock her up.
Thank you.
Hello. Thank you both so much for the talk. I have a question for each of you. For Professor McConnell, similar to the first question, you said that one of the reasons we might want presidential immunity from criminal prosecution is that they would be, like, sort of looking over their backs and, like, scared to make decisive actions if we didn't have that. But do you think all presidents before the Trump case were doing this and were scared of legal action because it hadn't been they hadn't been given official immunity until this case? And if you don't think that, then did we really need this case to make it official? And for Professor Mailer, you said that conservative jurists are usually more prone to be supportive of greater executive power. I was just wondering if this has also been the case throughout history. I was thinking, for example, in like the 30s, under the Roosevelt administration, he was sort of a very strong executive, and I was wondering if like conservative legal scholars and Supreme Court justices were still supportive of that strong executive back then. Thank you.
The view that you attribute to me, and I'm not walking away from it, but it does actually come from the Supreme Court. I didn't come up with this idea that presidents would be overly cautious. The language used in Nixon against Fitzgerald is that the possibility of subsequent liability would, quote, would render him, quote, unduly cautious in the discharge of his official duties. Now, that was 1982. That kind of protection has been in place since then. Why not before? I think, and this is total speculation. We're engaged in the game of what if. This is like historical counterfactuals, right? But presidents will not bring suits against themselves, so we're only talking about former presidents. A president who does not himself want to be subject to future prosecution might well think twice before doing it to his predecessor. President Biden and this administration is the first time in American history that there was a serious threat, and of course more than just a serious threat, of that being done other than in the case of Richard Nixon, where the whole process was preceded by the possibility of impeachment and then resignation and effectively confession on Nixon's part. But other than that, it's new. And I don't think very many presidents worried about it very much, because I think they expected their successors to obey the norm that you just don't bring prosecutions against their, the prior administrations.
Yeah, I mean, your question is a great one for me. I would say that the modern era of more, kind of conservative-leaning justices supporting broader executive power, would begin maybe in the 1980s and forward, and it really has to do with the way in which they have envisioned the president overseeing the administrative state, and in particular, kind of presidential control over the administrative state, maybe combined with more immunity too. And so I think that I would distinguish that from an earlier era. And when I was thinking back to the earlier era, I think what's more important in that moment is the fact that we had more people from the political branches sitting on the Supreme Court at that point. So like Justice Taft, as a justice, had a different perspective on executive power than some other justices. So I think that there was maybe, less of a, kind of Republican versus Democratic appointee dynamic than a dynamic having to do with, kind of the other capacities that the justices had been involved in. And even, Chief Justice Hughes had, various kind of executive branch leanings, right? So I think there was a different orientation towards the executive among, people across political parties at an earlier moment in time. And I think it is unfortunate, actually, that the Supreme Court now has really no one who has experience in the legislative or, maybe executive branch, Elena Kagan, but not as serving as a elected official either, right? So I think there's a difference in the way in which the court can deliberate about these issues when it has members who have had experience in the other branches as well.
Thank you both.
Hi, I believe Professor McConnell first brought this up, but my question is for either or both of you. My understanding or interpretation originally of Smith's characterization of that one should be perhaps more fearful of being found civilly liable than being convicted criminally was more to do with the likelihood of being prosecuted or being found liable or being criminally convicted, and about like the burden of proof and the difference between the burdens of proof in either of those kind of cases. So I was curious if that was the interpretation that either of you found or agree with, or if your interpretation was more that that was, I believe you characterized it as illogical, as the consequences of being found criminally convicted would be much harsher than found civilly liable.
I mean, I think if you did a chart of all the things that makes one more dangerous than the other, you'd certainly have some items on both sides. Burden of proof is a good point. I don't believe I remember seeing it that mentioned in either the briefs or the prior cases, but it's a very good point. One reason civil litigation is more dangerous, might be thought more dangerous, is anybody can bring a suit, right? Whereas only prosecutors can bring criminal actions. Trouble is, if those prosecutors are if they are the appointees and the arms of the other political party with I hate to use the word weaponization, but weaponization comes to mind. Maybe they are I think the logic today is that that's more dangerous. But, there are arguments the other way. tote them up on both sides and see what you think.
Did you have a thought or?
Yeah, I mean, I would agree with Michael's account of that. I mean, I think that there is maybe more possibility of proliferating civil litigation, right? So that, just because there are so many more possible plaintiffs, and, you might think that, there are some checks and balances within prosecutors' offices, but I think the more you move towards the model of, full presidential power over, kind of prosecutorial discretion, then the more you move to the model of saying that there could be political prosecutions.
Thank you both.
Hi, I'm Brian. I just wanted to ask a quick question, I guess, about immunity in relation to democratic legitimacy. So I've heard before in terms of not necessarily presidential immunity, but like qualified immunity for police officers, how that's put into question trust between communities, like on the local level, and say officers. And so just wanted to extend that in terms of like the American populace to the president's powers and their actions, and what your thoughts are in terms of this in relation to the topic at hand today, just because it's something I've tried to think about with everything going on currently, and also thinking back retrospectively with what was brought up about Obama and past presidents.
So, yeah, I mean, I'll start off. This is actually part of the problem I have with the broader immunity decisions, apart from presidential immunity. And I would actually maybe look to the idea of state sovereign immunity, which also is not, is a kind of concept built out of the 11th Amendment of the Constitution, but is not textually required by the 11th Amendment in its very literal sense. So in that case, I think there are a lot of arguments that, well, why should a state be immune from liability, when a citizen of the state is bringing suit against the state or bringing a claim, and that, suits are a way of rendering a governmental entity accountable. And so why should we be sort of taking these governmental entities outside of that form of accountability, especially, and I think that's the case especially when other ways of rendering governmental entities accountable are failing, right? So if impeachment is, not really proving a sufficient device or remedy anymore, then how are we going to find a way to make government accountable? Of course, there are elections, but then, I think it's interesting that this case is very much about, kind of the possibility of interference with elections, right? So how do we ensure that democratic accountability is preserved in all of these circumstances? And I guess, I would sort of share the worry that I think your question is expressing, that a lot of times decisions about immunity are maybe depriving the people of a particular form of accountability more generally.
So qualified immunity, which applies to most officers, but in actual practice, is an extremely common thing with respect to police officers, law enforcement officers. That's almost the whole ball game for qualified immunity. Was said originally by the Supreme Court to be based upon common law precedent. I think many legal historians have brought that into question. It doesn't actually seem to be so. And also the modern Supreme Court version of qualified immunity is thought by many, including myself. I even said this in some judicial opinions back when I was a federal appeals court judge, that this kind of qualified immunity is way more than makes any sense. So what the Supreme Court now says is an officer cannot be sued for abusive conduct, unconstitutionally abusive conduct, unless there is unless that conduct is specifically forbidden by a prior Supreme Court decision. So that means that there has to have been another officer who did pretty much the same thing, and that's it. That I think, for one thing, I think that makes Supreme Court decisions look like they are the law of the land instead of the Constitution itself being the law of the land. And I think something more like good faith immunity, where the officer gets immunity only if he can show that he acted on the basis of a good faith belief that what he was doing was legitimate, is all that is needed here. But we're really getting into the weeds.
Okay. Yeah.
Hi, I have a question based on Professor McConnell's presentation, but I would love to hear both of your opinions on it, which is the claim that the potential ramifications of absolute immunity shouldn't be too scary. I found Justice Sotomayor's dissent making the case to the contrary to be quite instructive. Like taking, for example, the election case at hand, I don't find it very convincing that deploying a vice president in their ceremonial duties in the election to overturn an election or to organize fraudulent electors to be a legitimate official duty of the president or a core constitutional function of the executive branch, but the majority didn't say as such in this case, and they, I think, kind of skirted putting any like clear limits on what is going to be considered an official act of the president. So I would love to hear from either or both of you about how you think through the kind of worst case scenarios, or why this wouldn't be a concerning decision.
Well, you're right. The majority did not discuss any of the facts of the case because they were setting forth what they thought were legal principles rather than applying those principles to this particular factual circumstances. When they refer to official duties, this is a term used in Nixon against Fitzgerald. That was, 42 years ago when that language was first used, and has not led to confusion. I think this was a point of mild disagreement between us because Professor Mylar was talking about how the boundary there is uncertain. Certainly the boundary is a little uncertain, but I don't actually think that it's proven to be unworkable in practice. Interestingly, in the oral argument under questioning mostly from Justice Barrett, Trump's lawyer was asked, well, is this a series of about 5 questions? Well, how about this? Trying to get electors to, do one. And he said that would be private. That would be private. This is Trump's lawyer admitting that many of the specific things would actually fall on the private side of the line. The things that he did that I think were really reprehensible are there. Now, it is true that he tried to persuade Vice President Pence of a cockamamie constitutional theory about Pence's authority. And Pence rightly rejected this. I hope it's not criminal for officials to try to persuade each other to do things based on cockamamie constitutional theories. This is trying to persuade somebody based upon a bad argument. I mean, we lawyers do that all the time. Maybe there are Section 9 sanctions. And then Pence said no. And what's more, I would like to play out that scenario just a little bit. If Pence had gone the other way, I also think there would have been no chance that it would have worked for Trump, because so the claim was that Pence, as vice president, that is to say, as president of the Senate, would refuse to recognize certain electoral votes as the electors come on. Well, under the Electoral Count Act, had that happened, the question of whether to recognize those votes would then be sent to votes in the House and the Senate. So it would be Congress, not Pence, who would make the final decision about this. So what I think the Trump people were hoping was that this would just put enough smoke in the air and maybe create some delay time for a little bit more confusion, and thus give state legislatures a little bit more time in which to do some shenanigans. And they weren't going to do the shenanigans anyway. So I just don't get that upset about it. And those were the only official acts. The instructions to the Justice Department and the talking to the Vice President were the only official acts that were affected by this. Most of what he did, so when he went down, for example, to Brian Raffensperger in Georgia and tried to get him to drum up additional, some more findings of fraud, that is not by any description an official duty of the president. He was acting in his capacity as the candidate, not the president. The president has zero authority over the counting of votes in the states. It is a state matter to count the votes, right? So, and similarly, contacting state legislators, and asking them to do something at the state level that would overturn the election has nothing to do with any official presidential authority. So I consider this decision to have been relatively narrow and not particularly alarming.
So I think I disagree a bit there, because I see the identification of, kind of conversations with the Vice President as official acts as not having a sufficient limiting principle here. And, I would agree with Michael that, just trying to persuade the Vice President of something or et cetera, probably shouldn't be considered a legal violation. But that, I would probably go the Barrett route again and say, like, well, maybe that's within the constitutionally protected orbit of what the president is doing, rather than that there's some immunity for, interactions with the vice president, which is kind of left not particularly defined for lower courts. And then the second part of that is that I think that, given how many district courts are, kind of issuing very broad opinions, or, seemingly, going out on a limb in a lot of respects, that there may be ways in which we should be more worried that, a kind of erratic district court will run with something from the opinion, because it is not giving sufficient definition to what constitutes an official act in this context.
Thank you.
My question is mainly for Michael. Like, expanding on the official act, one of the Supreme Court justices in their dissent said that the president could hypothetically do things like send out a SEAL team to execute political opponents, and if it would be an official act, it'd be exempt from prosecution. What do you think of that argument? Or the president hypothetically doing very dictatorial things, like publicly trying to arrest political opponents?
I cannot imagine that would be viewed as within the presumptive powers of the president. It seems to me it may be official in the sense that what he's doing is issuing order. It is not within one of those exclusive inherent powers of the president, so it's an official act, only presumptively protected, and it just seems to me that the more bizarrely horrendous the hypothetical, the less likely it is that any real court would find that it is within the presumptive protection. I could be wrong.
This will be the last question of the afternoon.
Thank you very much for the discussion. In the UK, there is no legal immunity against the Prime Minister for any criminal acts. And that was played out in English legal circles with the questions about whether Tony Blair should be prosecuted for his role in the decision to join the coalition of the willing and invade Iraq in 2003. Nothing was actually brought at the time. There were suggestions that the ICC should be tried before the ICC, but there were no war crimes to think about. There was an inquiry that was undertaken, but again, no war crimes were found. I think there was a novel attempt as well to try to create a crime of aggression under English criminal law, which was thrown out. But the question I really wanted to bring to Professor Milo was from a public policy perspective. The Blair administration and Blair was dogged by this from 2003 until he stepped down in 2007. And from my understanding of your arguments against presidential immunity, you're saying that people need to have their day in court, and the president should be on the receiving end of that as well. Is there not a case that the policy argument is going to be difficult to see through because politics is difficult enough as it stands, and a president, like a British Prime Minister, will just find themselves thinking about their court cases all the time instead of doing the difficult things of looking after difficult political decisions and getting on with the job that they're elected to do?
Yeah, I mean, so I think that there's a big difference between a sitting president or sitting prime minister and a former president or prime minister, because I completely agree that it's not appropriate for, a sitting president to be weighed down, except in cases of impeachment, by having to be, kind of contemplating prosecution or contemplating different forms of criminal liability. I think that, after the term in office is done, though, that, it's not so exigent that they be spending all of their time on official matters. And so to me, it feels like a very different case in terms of the kind of policy pragmatics of the situation. Now, I do recognize that, there can be some kind of weight, put on the scale in current actions by the prospect of future prosecutions. And, you mentioned the ICC, and I think, the U.S. is one of the few, few countries that doesn't really abide by ICC, kind of judgments. And so I think, any other country that's bound by the ICC might, the leader might be thinking about whether they are committing a war crime or whether they will be prosecuted by the, in the ICC for any kind of official acts. So, there's international responsibility as well as responsibility within a particular country that many leaders face. And I think, it hasn't appeared to be a huge burden in a lot of contexts, especially when it's not the context of a sitting prime minister or president, rather someone who's already out of office.
And Professor McConnell, do you have any thoughts about that?
It just seems to me that your account of the Blair situation just goes to show that that the criminal law is not a very good instrument for controlling questions of foreign policy. If I understand you correctly, I was not aware of some of this, but the idea that the Prime Minister of Britain could be, I guess the answer is he can't be, but the idea that he could be criminally prosecuted for entering into an alliance to fight against Saddam Hussein strikes me as ludicrous.
So,
Thank you.
before thanking our guests, let's put up the poll again. Take out your cameras, and let's see whether and to what extent the results have changed.
Do we get to vote? My single vote would change the thing by a percentage point.
All right, so can we put up the poll result? All right, there was some movement. So with that, let me thank both of you again for a very, very thoughtful and erudite discussion.